Welcome to Retirement, the Great Escape Plan. I'm Jenny Brown, CEO of JBS Financial Strategists and author of Retirement, the Great Escape Plan. This podcast is about rethinking retirement, not just the numbers, but the life you're planning for. In each episode, the JBS team, along with special guests, will explore real conversations, real experiences, and the decisions that help people approach retirement with clarity and confidence. Because thriving should be fun and naps should be epic. Let's get started. Hello and welcome back to Retirement, the Great Escape Plan. I'm Jenny Brown. In our last episode, we talked about the idea that legacy is more than money, that legacy is about relationships, values, and clarity, not just what's left behind, but what's understood while you're still here. Today is a natural continuation of that conversation, because once people start thinking about legacy, the next question is often, okay, so what do I actually need in place? And that's where things can get confusing. Wills, estate plans, superannuation, powers of attorney, documents people think that once they're done, until something happens, they realise that they haven't done them properly. So today we're talking about the real stories, the moments families face when documents are outdated, assumptions are wrong, or conversations never happen. I'm joined by estate planning lawyer, Chhabra, and my business partner and financial planner extraordinaire, Hanna. So welcome to you both.
Thanks, Jen. Looking forward to the chat.
Thank you, Jenny and Warren, for the opportunity to be part of this podcast.
It's great to have you. So, Warren, I'd love to start this conversation off. And, in terms of, we often see, the firsthand, how these issues show up in advice meetings long before we get lawyers like Love involved. And, and people really think that they're on top of their estate planning or they're on top of their documents. So do you want to start us off by talking really about, what you're seeing on a day-to-day basis around this?
Yeah, thanks, Jen. It's great to have this conversation. We've obviously been working with Love for 12 plus years, I think now, mate. So it's really good to be able to share some of the stories that we've dealt with and some of the client experiences. Because I guess from our side of the table, our job's all about identifying problems and considerations with clients. And often we get a number of questions around estate planning. And while we've got a good understanding of it, it's great to work with a guy like Love who is able to make often the complex simple. So I'm looking forward to today having a chat with him about how do we do that? How do we articulate to clients what some of the problems areas are, some case studies, some examples of that, because, we see both sides of it. Unfortunately, dealing with clients, we see the good side of retirement, wealth creation, all that sort of stuff, but we see the other side of it too, incapacity, death of a loved one, all that sort of stuff. So to have all these documents and systems in place is really important. So looking forward to the chat. So thanks, Jen. Yeah.
Cool. So, Love, I'd love to start with the belief, and we hear all the time, I've got a will, so I'm sorted. So from your perspective, what do people really misunderstand about the difference between a will and a broader estate plan? And why does that misunderstanding really matter so much with families?
Yeah, very good question, Jenny, to start this discussion. So will is an important document. Essentially, I would call it the cornerstone document of an estate plan. Essentially, it guides who's going to manage the estate of a person after their death, they pass away, how the estate is going to be distributed, and if there is a dispute, they'll be the ones representing the estate in that dispute. So it is an important, really important document. But based on what's happened over the last few decades, people's lives have become a little bit more complex than they used to be. I still remember when I started practicing law, family trusts were used by businesses and for investment purposes, but they were not as common as they are now. And self-managed superannuation funds also, grew in popularity over time. Then you've got people who run businesses through companies and other structures. You've got here, so you've got these assets which generally do not form part of someone's estate, but they may have control over those assets. So an estate plan looks at the succession of control of those assets as well as what's in one person's name. Then when people say, well, I've got a will, like everything in life, our circumstances evolve with time. Is the will still relevant to your current circumstances? Now, I'm not saying everyone should look at their will every year and see whether it's relevant or not, but there should be milestones in life which should prompt a review of their estate plan. For example, someone establishing a new trust to buy a property or starting a business and there's a business partner involved. I'll give an example of a scenario where we were asked. So in terms of our practice, we do estate planning. We also do probate administration and estate disputes. So we are a wills and estates practice. Within that umbrella of law, we do all the sub areas, but we don't do anything outside. So we have the privileged position to be able to see when a estate plan is done, if someone passes away, how the estate is administered, and if there is a dispute, what triggered that dispute. So I'm now assisting a family where the will was done by lawyers, and essentially that person had assets in their personal name, but also various assets in the business they did. Now they had the intent, and it was a blended family where they've left some portion of their estate to a child from a previous relationship. However, once the administration of the estate commenced, it became quite clear that this person's, as most people who run businesses, there's a little bit of risk attached. They don't really carry a lot of assets in their own name. So a lot of assets ended up being in these trust structures, and the distribution in the will doesn't actually reflect what the overall intention was. And now there is a dispute between the families. Now, I'm not saying the lawyers did not do something which they were supposed to do. Could be a portion of that, but maybe over time, as this person's business evolved, they should have done a review to see whether my overall wishes are still reflected in my overall estate plan rather than just the will alone. So that's an example of that.
So based on that, if you're running a business, how often should you pull out your estate plan and your will and your powers of attorney and review it? At least read it and know what's in there. Every 5 years, or I mean, obviously as things change, but is there a rule of thumb that says every 5 years, 6 years, 10 years, or there is no rule?
Yeah. So the other thing I wanted to add just to my earlier comment is, so death is an important factor, but the estate plan also looks at incapacity. I'm going to go back to the example of self-managed superannuation funds, companies or businesses. Incapacity, if you've got power of attorney, the person is able to make decisions on your behalf for your personal affairs. Now, if you own shares in a company, that person is able to make decisions on behalf of that shareholding, but that person ultimately does not replace you as a director of a company. Now, if you're operating that company with other directors, you've got to look at, if you as a participant in the business have lost capacity, how's your family represented in that business if you run it with someone else? Or if you've got multiple children working with you or other people working with you, who's the right person to take that role? So the estate plan is going to look at not just death, but it's going to look at incapacity from financial decisions, personal decisions, medical decisions, where you live, what food you get, what services you get, who comes to visit you, what medical decisions are made. So that's the estate plan. Now, in terms of your question about how often the review should be undertaken, look, I would suggest that it depends on the circumstances of the person. If the circumstances are not largely changed, then one could be comfortable with the plan they had and the circumstances remain the same. For example, a family with 2 children, husband, wife, or partners working, and they've acquired a home and now they've bought another investment property. Yes, their estate has grown in size, but the family still remains the same. The wishes regarding the distribution still remains the same. Not necessarily a review is required. And that could be their life for the next 10, 15, 20 years, where they're accumulating super and have got an investment property or other personal assets. However, if someone then decides, you know what, I want to buy this property through a family trust, And then they need to look at, are they structuring the trust deed or the control or succession of control of the family trust properly? Or I now want to have a self-managed superannuation fund, and I'd like child A to be a member with me of that fund. Or what if I lose capacity? I would like child A to operate that superannuation fund in case I don't have capacity. Then you've got to look at whether that aligns with your overall estate plan. Same thing if, of course, there are other trigger events like death in the family, divorce, separation. People sometimes don't understand that that they're already under stress because of a horrendous event like separation or divorce or death happening in their family. So the last thing is that they want to look at the estate plan, but that should be a priority in those circumstances, because separation doesn't automatically mean that you've got a financial settlement pending. So, but if you pass away, the affairs could be structured in a way that you've got joint assets and they're passing to the spouse, whereas the spouse may have a different partner in life, So you've got to really look at those trigger events, and that's where the advisors definitely come into play. The financial advisors or accountants are often very good to pick up those events and say, hey, have you looked at that documentation? So those should trigger a review. So in my view, key events like marriage, death, divorce, or entering into relationships. Now, a lot of people don't marry these days, and they can continue to live together on a general domestic basis as a couple for a period of time. Once that period moves beyond the 2-year mark, you've got a person to whom you have a moral obligation to make adequate provision for their proper support and maintenance. Have your documents catered for that? If not, there's a potential claim on the estate. So for me, it's not so much the time, it's the trigger of change of circumstances, or as the circumstances evolve. But having said that, it's very hard for one person to go, oh, I've got this event happening, I should look at my. So I do agree with you, Jenny, on a practical level, if you have a 4 or 5 year mark or 3-year mark, just to look at it, especially when the life is evolving, that'll be a good idea. Yes.
Yeah. I mean, one of the things that we like to do is every time we catch up with clients and we go through what we call a discussion document with a client, is to review where their will is, who the legal personal representatives are or the executor, who's got the power of attorney, and do the sort of family know the wishes. So I think that's key from, just prompting that with clients, because that in itself has often led to, oh, yes, we probably need to review our estate planning. And a follow on from that is that often we get asked is, well, who should be the executor? And how do I choose the right person to be the power of attorney? Now, if I came to you, love, and I'll use, me, how do you guide me as a client to make those decisions? Because sometimes they're not cut and dried and straightforward.
Yeah, that's spot on, Jenny. There is no one size fits all. And that's why people say, I'll just do my will online, or I'll just go and get a post office document. There's no advice element. The document is not catered to the individual circumstances of the family. And that's why it really depends on the circumstance of the family. So when you meet a lawyer, any lawyer who operates in wills and estates, hopefully they'll go through the exercise of recognizing your personal affairs first, your personal circumstances. Who is in your family? Who's you're a couple and you've got children? What are the circumstances of the children? If they're minors, who else is in your broader family whom you can trust? And then they can guide you through that. And then from moving on from personal circumstances to financial circumstances, what financial affairs or other circumstances these key positions will have to deal with? Are they dealing with a vulnerable beneficiary where a trust may be included in a document for long-term purposes? Or are they just dealing with an estate where it's a matter of collecting the assets and distributing the cash, or selling the property and distributing the cash to the beneficiaries? Or are there other long-term trusts included? Is this person going to manage minor children, and are they going to be looking after the residence accommodation, schooling, and other things for the children? Or is this person required to also administer a family trust? And if the family trust which they've created during their life has this person in themselves as a beneficiary, is there a conflict of interest? So those kind of discussions will come into play. So the best thing is you look at where you want the benefit to go, and then you look at the circumstances of that benefit, and is that the right person to hold that controlling position? And if the beneficiary of that potential gift or this of is not, at the time is not capable or is appropriate for them to have that control, then who is the good replacement or an interim party to hold that position? That's the analysis we undertake when we meet with the client.
It is a very difficult conversation often with clients, because they've potentially got someone who isn't financially savvy enough maybe to be able to do that role. And often there's also elderly people as well. So, you can't necessarily nominate maybe your parents, because it might not be appropriate for them if you're dealing with a good estate plan should be in place for a longer period of time, I'd have thought, love. So, you want to make sure that there's longevity in those people as well. What is a potential solution that's maybe available to some individuals who don't have that ideal person to deal with? Is there a solution there?
Yeah. So if there is no one appropriate, so I always say look within your family and close-knit group first, because those people are not going to charge for their services, and if someone who's also a beneficiary is going to receive that role, it's in their interest to administer it properly so they can move on with their lives and obtain the benefits. So you always start with the family first, but families are complex. You've got I've got clients where they find it very hard within their own children group, the group of the children, to select, because the children are not getting along. In fact, I'm now at this stage administering a matter where it was a blended family, and the couple met later on in life. They had a beautiful, about 2 decades together, but they both had adult children from previous relationships. And they both made the conscious choice that they were not going to appoint any child from any family, because the families were not getting along. So they appointed their accountant and their financial advisor together as the executors in this estate. Now, and then there was a charging clause included for those people. Now, these people were very happy for the cost of these independent professionals to be paid to minimize the potential for dispute between the beneficiary. So it's like a cost-benefit analysis. Yes, you can choose professionals if there is no one appropriate. And sometimes that is the way to go, because then the professional is bound by ethical obligations and the professional obligations and they're also bound to carry out the wishes. So many times we've come across wills where the wishes were set out in one particular manner, and people who were administering either didn't understand fully or were happy to modify that a little bit. So the question is, did the wishes of the deceased were they carried out properly? Because the people who took charge of that had personal interests, and they had a different view as to how they wanted to administer. So in certain circumstances, yes, definitely approaching professionals or appointing trusted professionals to undertake that role. And if you don't have those trusted professional network, then you've got the big organizations like equity trustees or Australian equity or state trustees. But then the charging clauses or the provisions for those big institutions is going to be according to their work and their standards. And so the criteria for me is always look within your group first, and if there's no one suitable or you've got risk to manage, then you look at independent professionals, and if there's no such person as well, then you can look outside to these big trustee companies. I'll give you one more example where I always consider independent professionals, at least maybe not the sole one, but one of the executors or controllers could be one of them. Is, for example, this is again a situation we come across very often, where you've got a family trust holding substantial assets, and you want that trust to pass to your children, but it's, as you know, that family trusts have a very broad class of beneficiaries generally, and if you appoint your siblings or someone else from your family as a controller of the trust while the children are minors, that person would also be fall under the beneficiary class of that family trust. So by giving them control of something which they can take or use for themselves, there is an inherent conflict of interest in risk. Yeah. So would you then better off putting at least one independent in the mix as a check and balance to ensure that your wishes
An
and rational
umpire.
distribution.
Yeah.
That's exactly right.
Yeah. Yeah.
Hmm.
So talking about those powers of attorney, there's been a few changes in recent years. So often I'll get you'll get a client in who's been a longer term client. We've done our will, done our estate planning. A lot of our conversation is around, you might have moved house, but predominantly the goal of that estate plan is still in place. But they've done a power of attorney. There were some recent changes now where I think there's 3 different classes of powers of attorney. Is that enough of a trigger to need to update your power of attorney if you did it 5 or 6 years ago and now it doesn't include all those different 3 classes, do you think?
So one thing government, and rightly so, as circumstances evolve, legislation changes over time. And these powers of attorneys, they are under statute, they're creatures of statute. So the legislation allows people to delegate, for example, their authority to make financial decisions on their behalf. What are those financial decisions? It could be as simple as accessing bank accounts to pay your bills if you're not able to do that. And then it could also involve selling assets. If you have to, for example, elderly parents have to move to care facility, and sometimes there's not enough capital, so the house needs to be sold to provide for that ingoing contribution to the care facility. The power of attorney can do that in that event, and then make sure taxes are being paid off. And sometimes the decisions can be a lot more complex than that, is managing, again, businesses or interests in companies and trusts and self-managed superannuation funds representing the interest of a member who's lost capacity. So that's from a financial point of view. Then you've got the personal power of attorney, deciding where you live, what food you get, what services you get, who comes to visit you, which care facility you go to. Those are the decisions. And then, of course, there's the medical decisions as well, consent-based decisions to doctors. Now, these 3 powers have always been in legislation one way or the other. So at some stage, we used to have the guardianship, and that changed to now power of attorney for personal matters, right? But Australian legislation, there is a cross-border between all states recognition of powers of attorneys from the other states. So that's one point I want to make. But all states and territories have their own kind of forms how they operate, but they do recognize to some extent the power of attorneys from the other states. But also the legislation generally, when it's updated, preserves the previous documents. Now, having said that, it is always a good idea to update them over time, because again, the circumstances could have changed. Is the person you've nominated as the primary attorney an appropriate person? If you've got let's say parents appointing each other and then the children as the backup, if the parents have both lost capacity, every time the child has to use the power of attorney, they have to prove evidence. Yes, parent 1 has lost capacity, parent B has lost capacity as well. Also, the third parties may say, oh, well, this medical certificate of loss of capacity is 6 months old. Can you get a new one? There are all these administrative hurdles in place when you are doing that. Then, legislation now allows a lot of authorizations and restrictions to be placed on the decision-making process. For example, if you've got multiple children making decisions, are you allowing, are you saying that any one child can make a decision? Great. But do you want to bind them to make certain high-level decisions together? If there are other children in the family, should they be notified? Because a lot of disputes we see between families arising from the use of power of attorneys come where one child or a sibling says, I don't know what the other person is doing, or they're doing something which I'm not happy with. I have no visibility how this money is being spent. And then you've got to go to VCAT to apply and to have all that. So yes, it's a good idea to always review your documents over time to see, do they still reflect my intention? Have I got the right people nominated for the role? And have I put the right authorizations and conflict provisions in the document? For example, I'll give you this example where, again, a blended family, this couple had been together for a while. Now the house was in the male partner's name, and the female partner was residing there for more than 20 years. Now he lost capacity. He had to go to a care facility, and the house needed to be sold. And his children were saying, well, we need to use the other assets which are in the super fund to pay for that. We want to preserve the house because in his will, they were going to get a portion of whatever it was. But for her, she says, I can't maintain this house on my own. I need to downsize and I want to buy something else which is smaller and fit for me. And they were like, well, we're not going to use dad's money for you had that dispute, and everyone ended up in VCAT. VCAT had to make that decision. And she was the power attorney.
Mm.
Yeah, but because the power attorney didn't authorize her to enter into any transactions where there was a little bit of conflict of interest, she had to go and get VCAT involved. So had there been an analysis done, what are her future needs? Is this power attorney suitable for her if she's acting as the attorney? So those are the kind of things I'd say we should trigger a review for the documents.
So in that case, how should the power of attorney have been written?
First of all, the foremost criteria is what are the wishes, of the person who's giving the power, and what are the circumstances of the family, and what advice they've been given. So ideally, you've got to look at, okay, where this family is going to be in the next 10, 15, 20 years, and what are their needs, and is this power attorney document suitable for their needs? For example, if the house was in name, maybe the document should have said, if most of the assets of the family were in his name, that his assets could be used for her personal expenses and liabilities. And if she's acting as attorney, some bypass of the conflict of interest. So example, if you are acting as attorney for someone, the legislation says you have fiduciary obligations under legislation and under common law that you have to keep your assets separate to that person. You've got to keep proper record. You've got to use their money for their benefit, not take any benefit yourself. These are some of the duties which are imposed on an attorney. Now, you can bypass some of these things by authorizing them in the document. Yes, I know that there is this obligation, but I want this person to take benefit for their personal expenses, for their medical expenses, to the extent their own resources are not enough. Or if they need to sell this house, they can sell the house and buy a smaller residence, as long as it still remains in my name, so they can live in that and they don't have to pay, or the upkeep has to come from. So you can cater for all those things within the document in advance. So that had that done in this matter, it would have been very hard for the children to put a stop to everything and require VCAT to make determination on it.
So is that type of power of attorney common? Because I must say I probably don't see a lot of complex ones or left field ones, but I haven't seen many that are like that.
Yeah. So we definitely include various authorizations and limitations in the document when we draft them for the client. And that's why online documents or just doing it yourself, DIY documents. The thing is, yes, technology is taking a very steep upward curve where people have access to a lot of information. It's a great thing because then they have ability to assess the information they're receiving is good or not, or ask the right questions. But we are not trained in everything. Like it's like saying to Dr. Google, I've got an ache in my wrist, and I'll upload my scan. Can you tell me what medication I need? You still want to go to a doctor to do the human verification. I am doing the right thing, and that's where I think it's important for the role of the lawyer is to verify, and lawyers are going to be using technology as well. In fact, those gone are the days where you're sitting there typing a lot of documents from scratch. You use technologies. That's why the cost of the service is not going up dramatically, but the service is still a very important service where you check and verify and you assist and you guide the client, because technology is as good as the input you put in it. So if you don't know the right questions to ask, you're not going to get the right answer. And is the answer right or not? Who's verifying that? You're not going to be able to sue technology if something goes wrong, whereas you can sue the lawyer if something doesn't go right.
Yeah. And that's spot on. It's the questioning and it's the getting to the bottom of truly what is important to the client that's so important in these sort of conversations. Is a general rule, and I know you've got to be careful with the specific advice and all that sort of general disclaimer, but like most requests from clients are able to be done to some degree, I would have thought, within the rules. But how do you deal with someone who really, really wants to rule from the grave? They want to say, right, well, this asset goes here and this asset goes there. Can they preserve assets for years and do all this sort of stuff if they really get it right? Or is it there is an overlying sort of interpretation that you have to be fair and true and equal to people as well, I guess. How do you deal with someone who really wants to be strict?
Yeah. So as a general comment, we all have testamentary freedom. We are entitled to, if someone's worked hard or have got assets, whichever way they've acquired them, and they should be able to decide what happens to those assets after they've gone. The system allows that freedom. However, the system also imposes an obligation on people to be just and fair when designing their wills and estate plans. What does that mean? That means that there's a criteria in the legislation who's an eligible person to make a claim if the person to whom the deceased had a moral obligation to make adequate provision for the proper maintenance support, they've not done that, and that person has the ability to make a claim. Now, yes, there's a list of various criteria, various people who meet that criteria, but then depending on who that person is, there is degree of moral obligation, and also, for example, moral obligations towards a spouse or domestic partner is very different to an adult child who's financially independent.
Yeah.
Very different to a child who's minor, and then again, very different to a child with special needs. And when it comes to control, well, people generally, in my experience, and yes, sometimes you've got fine people who have, that they have very particular needs, but you've got to look at where is this coming from? What has their life experience been for them to think like that? Because sometimes these triggers are there embedded from the experience of this person's had over time, and they're protective of that asset. And it's a valid concern this person may have. So yes, you can put in place structures, trusts, and design the control of the trust to provide that ongoing protection. For example, blended family is a prime example of these kind of situations where you've got a situation, you've got a new spouse and children from a previous relationship. Now the person says, I want to look after my new spouse, but I don't want my assets to go to his or her children after they're gone.
That's a big one. Yeah.
Yeah, that's right. And it's a very common one. So you can put in place trusts or structures in the will where you're preserving the benefit for this person during their life. So they have access to the assets or capital or income, or a combination of the two. And after their death, the assets do come back to your children. Is that the right trust? Or should there be some other sort of arrangement? So there are very different types of arrangements you can have in your documentation. And to answer your question, Warren, to further answer your question, yes, there is an ability to be able to control how things are done in the estate, but then there should be limitations, right? Because where you've got a child or children where you're passing on the estate, one needs to be at some level become comfortable that I've done my bit and I've provided the right structure to my children or my other family members. Then it's up to them how to manage it. Because if someone doesn't like the structure they've been given, they will either challenge it or they'll try to find ways to get out of it. And that could be expensive, and that could fracture the family. They could cause disputes. So it's a fine balance between the two.
Yeah.
Certainly.
So just a follow-up question on that about a bit of a myth, so to speak. Maybe we've been watching too many movies, mate. I don't know. But if you're there's a sort of a fear that there's no downside of making a claim. So if I've been left out of a will, I may as well have a crack because the estate pays for it. Is that true? Like, is that fair?
Yeah. And look, it is concerning that view continues to be in the community, because there was a time when people who could challenge the estate, the category was quite broad, and I don't think the legal profession helped itself as much, because lawyers were sort of promoting, I would say, really sort of assisting these people to bring forward claims with that kind of view. And there were some lawyers, not all, there are always some people who kind of push the legislation boundaries a little bit. But I think over the last quite a few years, the legislation has been refined to very clearly specify, first of all, who has the right to make a claim, under what circumstances they can make a claim, and even if they have a right to make a claim, is it appropriate to make a claim? Does the claim have merits? Because there is no under general rules of litigation, if you sue someone and you lose the case, you are liable to pay not only your costs, you can also be made liable to pay the costs of the other party, right? That's the general cost follow the event. That's the word we use in legal industry, that if you've lost, you've got to pay your costs and pay to some degree cost of the other party. But sometimes in estate litigation, you can move away from that. But then the question is, what triggered that dispute? Is this appropriate for the estate to then fund its own costs and the costs of the claimant, despite the fact that the claimant lost? Is it appropriate for the other beneficiaries to fund that cost? And those circumstances will depend on what were the reasons for issuing the claim. Was the claim settled, or the person, how was the claim handled? And in fact, now, Warren and Jenny, there have been instances where the cost order actually has been made against lawyers for continuing to push these things, and if they've not run the case properly. So I think people have to be very careful when they issue these proceedings. For that, I am not happy with what's been left in the will. They should seek appropriate advice first to say, first of all, are they eligible to make a claim? Then, if they are eligible, and does the claim have merits? And then what is the degree? And not only that, after that, how do they run the claim? Have they given appropriate consideration to, am I being reasonable in my offers about settlement? Or am I being totally unreasonable? Because you could have eligibility and merits, but if you're so unreasonable in how you've run the claim, unnecessarily raking up costs from both sides, the court's not going to be happy with that.
That's good to hear.
So, yeah.
That is good to hear. And that just circles back to the whole point of the podcast around making sure that, gives you comfort that if you go and seek advice and you put a strategy in place, there is that support mechanism to make sure that it isn't just going to get claimed upon and all those sort of things. So good. Thanks for clarifying. That's awesome.
Yeah. And we actually, in our job as lawyers, and I'm sure you can speak for yourself about, your job as financial advisors, I suppose, is to give advice, right? To show them the options, the consequences of adopting one option versus the other, make a recommendation. But in the end, we are bound by the instructions we are given by the client. So we have to draft a document because the client has to sign it and say, yes, I approve. So but hopefully the clients will take the advice on board. And we see that we are able to modify their initial thinking once they've received the advice. They say, yes, and then sometimes the client will say, yes, I get what you're saying. I still prefer this, or I'm happy to meet at this level. So I accept that risk to this degree. So they can accept the risk and still have that strategy in place. Yeah,
absolutely. So I just want to change tact a little bit and talk about superannuation, because we've touched about, wills and estate plans and power of attorneys and stuff, but we haven't actually spoken about superannuation. And a lot of people assume that superannuation will just go, follow the will and go to the estate as the will's sort of drafted. Warren, I want to bring you into the conversation here. What have you found, and how do you explain to clients that that's actually not the case? And what do we need to put in place? And then how does that dovetail with what Love does with the estate planning?
Yeah, it's really interesting. A lot of people don't actually understand that super doesn't automatically form part of the estate. And so you need a nomination to some description on your super fund to make that really clear where it needs to go. And that nomination often needs to change over time as well. Potentially if there's insurance involved with superannuation, often life insurance or the like would need to be determined how that's paid out through the nomination. And obviously there's different types. There's a binding nomination, and Love can obviously explain it a bit more than me if you want to go down that path, but something that binds the trustee to pay it a certain way. There's a non-binding where it's an indication of how you'd like it to play, but if there's a better tax position, maybe that's the case. But some of the biggest things I've seen is that, particularly with some industry funds, retail funds, there's often a 3-year clause. So every 3 years you might have to redo that nomination. And if you don't do it, on the reverse, if there's a non-lapsing one where someone signed it off years ago and now had a divorce or had a change of circumstances, and it's a binding nomination, well, the trustee has to pay it potentially to someone that the intention these days wouldn't be that same person. So there's a real importance of ensuring that those nominations are done right. And then there's also the fact that some people have in their mind, well, I'm going to give the house to my spouse, I'm going to give my shares to someone, I'm going to give my super to someone. And paying the super to an adult child, for example, has a totally different tax consequence than what they really intended. So it's really important to tie super into that whole estate planning conversation. And that's where we use love to say, well, we always make sure that the client does the binding death benefit nomination so that it's really clear it's in place. But then we send that off to the client to take with the lawyer to incorporate into their full estate plan. Because there is some examples, and I'll get Love to maybe to have a chat about it, where would you not send, if you wanted to send super directly to someone rather than via the estate? Is there an example of where that's a positive outcome? Because sometimes that is an instruction.
Yeah. No, so Warren, spot on. First of all, superannuations are just trusts. These are industry super fund is a large trust. There's a trust deed at the back, and there's a trustee making decisions. Same with retail funds, and same with self-managed superannuation fund. Self-managed superannuation fund is like a small trust with a handful of members. There's a limitation on how many members, but generally, it's couple can start a self-managed, and sometimes children had to come and join them. Whereas industry funds and retail funds have large membership, but they're all guided by the rules of the trusts. And there is also a legislative layer on top. The legislation guides what they can do and what the purpose is and what they can't do. Now, will is a separate document. It deals with your personal assets, whereas superannuation is sitting in a trust. Yes, as a member, you have a member balance, and the superannuation fund has an obligation for you to maintain that member balance and pay out. But then the payment of that member balance or application upon death is going to be guided by what the deed of that fund says. And generally, deeds will allow members to make nomination to say where they want the death benefits to go after their passing. But you've also got to look at sometimes the member is receiving an income stream, which is, we call it pension. And so the member can make a binding nomination directing the superannuation to go to certain dependents for superannuation purposes, and there is a definition of what that means: spouse, children, anyone else with whom the member had an interdependency relationship. So you can't just nominate, I'd like to nominate my brother to get this, or my mother. So many times we hear people say, I've nominated so and so, but that's not a valid nomination, because in their mind they think they've nominated someone, but it's an invalid nomination. But then out of those categories, not everyone can receive superannuation death benefits tax-free as well, because the definition of tax dependence is slightly narrower, different to the definition of dependence for superannuation purposes. And then within that group, not everyone can receive the superannuation as an income stream. So there are all these different variables. So for example, if spouse is receiving pension or income from the income stream from the super, they can revert that to their spouse. So it automatically goes to their spouse. And then depending on the transfer balance cap, they can have two combined pension, or they may have to put some in accumulation. I'm going into technicals now, so I'll stop and come back to the normal. It's a professional hazard, so I suppose. But what I was trying to say is that you've got the rules of the trust deed which must be followed, and it'll set out if you can make a nomination. And then if you are nominating people directly, then you've got to think, is that the right thing to do? Maybe the right thing to do where the spouse is receiving benefits, or you want to keep the benefits out of the estate. There's a potential for a claim to be made on the estate, and you don't want those death benefits to be exposed, whereas except New South Wales have got the notional estate concept, but in Victoria, you don't have that. So for example, in blended families, it is often used as a strategy where you say, you know what, I at least want to quarantine my super from a potential dispute between this family. So I could give super directly to these people, and then the remaining assets are carried by the will. Having a simple direction in the will about the distribution of death benefits is inadequate. So there has to be something which links the super to the estates. For example, a nomination saying, actually, I want the trustee to pay all the death benefits to my estate. But then in doing that, you need to consider who's receiving those death benefits. Are they tax dependents or not? And what are the tax consequences? Is it appropriate? Is there a risk of a claim on the estate? All these factors come into play as well. And then is the nomination, currently the system allows people to make nominations, again, depending on each fund and what they allow. Some funds will allow you to make a non-lapsing nomination, which means you don't have to update it and it stays there until you change it. But other funds generally say it's based on legislation, which says every 3 years you've got to renew the nomination. And some funds will say you actually can't make a binding nomination. You just make a non-binding nomination, and the trustee has the discretion to decide where they want the death benefits to go. So you've got to look at which fund you're dealing with and what type of nomination is most appropriate in your circumstances, because there are tools where you can minimize the tax impact. For example, some people may get more of the super death benefits or tax dependent, other people get the other assets. So everyone's sort of ending up with a decent amount of benefit and sort of almost equal benefit, but the overall tax paid is a little bit less.
And it is something that evolves as dependents change in their status. So you might have one child who becomes an adult, one still a dependent. So for the benefit of everyone, it might be best to go to one kid from the super and something else compensated the other way. And that's why I guess just having an overall review and including the super is so important, because the tax savings can be significant.
I agree.
Absolutely. I'm really conscious of time. So we've gone off down this sort of road and rabbit hole and stuff. Love, is there anything that you'd like to leave the listeners with to wrap up, or before I sort of wrap up and close the episode?
What I'd like to say is I think estate planning should be an important consideration in everyone's mind. And you don't have to be looking at this every year or every 2-3 years, but as long as you've taken steps to ensure that there is a plan in place, because if we all have a plan in place, and the plan currently we have is provided by the government, a default plan, where if you don't have a nomination in super, the trustee of the fund will have a discretion. So they'll decide what happens. If you don't have a will, the laws of intestacy will cover what personal estate. Then, it's set out in the legislation. And then the question is, if you put a plan in place, then that's the plan you want rather than someone else dictating how things are. And because that may not be appropriate for your needs. And the advice element, I always say, yes, there are facilities these days to get online help or, go other local post office wills or so. But having the advice element is an important part of this exercise. People spend a lot of money on insurances every year, house insurance, car insurance, and whereas estate planning should be just one-off costs. And I think it's an important consideration. And I hope your listeners find this discussion useful. And it at least, if not nothing else, it prompts an inquiry in their mind. It triggers that for them to look at whether they're happy with what they've got. Yep.
Absolutely. Warren, any closing comments or remarks you'd like to make?
Love to summarize it beautifully, but I know that these days with the prices of houses, forced superannuation, insurance, maybe TAC claim, I want Love or someone like him looking after my estate, not a guy behind a post office.
Absolutely. I mean, I can speak personally, from obviously going through my estate planning, but also when my mum passed, just the absolute care and diligence, Love, that you and your team put in place to go through and make sure that we had some very tight deadlines because we'd sold a house and, things like that, but it was absolutely streamlined and perfect. So I don't know how we would have gone if we didn't have you in our corner. So highly recommend that anybody out there listening seek some advice if they need some estate planning. So publicly, thank you. So just in wrapping up, to our listeners, if there's one thing that I hope you take from today, it's this: a good legacy doesn't happen by accident, as we've just said. It's built through updated documents and honest conversations. It's also about reviewing these documents on a regular basis. So you don't need to do everything at once. But if you are listening and thinking we really should look at this, that's probably your cue to start with a conversation with the right professionals for your circumstances, because everyone's different. Retirement is about being more than prepared. It's about enjoying your life that you've worked hard to build, because thriving should be fun and that should be epic. Thanks for listening to Retirement, the Great Escape Plan. If today's conversation raised questions for you or simply gave you something to think about, that's a great place to be. Retirement isn't about having everything figured out at once. It's about starting the right conversations and taking thoughtful steps over time. You'll find helpful resources and references related to this episode in the show notes. For more tips and insights and practical guidance, we also invite you to visit the JBS Financial website, where you'll find a range of tools and resources to support you at every stage of retirement. You can also follow JBS Financial on Facebook, LinkedIn, Instagram, and YouTube for ongoing conversations, updates, and ideas to help you plan well and live fully. Join us next time as we continue exploring what really means to plan well, live fully, and enjoy retirement on your terms. Because thriving should be fun and naps should be epic.